The mother pushes back against overnight visitation, insisting the child isn't emotionally ready, while the father claims he's been cut off for over 70 days, arguing deprivation of contact is harming the relationship. The judge quickly identifies a serious custody conflict and confirms there's enough legal basis to proceed further. Both sides paint completely different realities, one focused on protection, the other on parental alienation, setting the stage for a major custody decision.
First, make the observation, this is the first setting in regards to this motion. The court has reviewed the motion, finds that it's properly verified, and does colorably state a prima facie case, which warrants this court taking further action in regards to this motion. Ms. Martin, are you opposing the relief sought in this motion filed by Henry?
For overnights, yes.
Okay.
I'm totally okay with him getting parenting time a few hours throughout the week and a few days.
Okay, you say that. Okay, let me stop you there. You've read the allegations in this motion, and Henry says that he hasn't had parenting time since December, if I recall. Why is that?
Because one night I was asking, he had her all day, and I asked him to call me after her nap. He did not contact me all day, and he'd already had her the day prior to as well. And I was just wanting to get in contact with my child and seeing how she was doing. And then it came into a whole argument that he wouldn't let me contact her. He wouldn't let me see her because he was too afraid that she'd want to come home if she's seen her mom. And so then I said, well, if you're not going to pick up the phone, then I'm going to show up and I'm going to take her home with me. And then he made me have to call the police to be able to even see her. So
the father's lawyer argues no meaningful contact since December, blaming interference from the mother, while the mother insists the father ignored calls and communication became overwhelming. A police welfare check gets mentioned, showing how quickly this dispute escalated beyond family arguments into law enforcement involvement. Both sides accuse each other of controlling behavior, and the court begins to see a pattern of breakdown in co-parenting trust.
And to get her back into my custody. So since then, the cop told him that unless there was a court order in place, that he could keep her for as long as he wanted. And I'm not okay with that because I'm the one who's been raising her for 3 years all by myself. He's been in and out of her life.
Okay, and the little girl is 3 now?
Yes.
Okay. I trust, Mr. Blanchard, that your client is still pursuing the relief sought in his motion for this court to adopt a new parenting plan?
That is correct, Your Honor. I'd like to have the opportunity to argue if the court will allow it.
You may.
Okay. Your Honor, we dispute much of what Ms. Martin has already stated. My client said that whenever has a child in that particular weekend, which would have been the weekend covering December 20th, that she was blowing up his phone with text messages and phone calls, and finally it was interfering with his opportunity to have meaningful contact with his child, and he just stopped responding and stopped taking her calls because it was just relentless. And then she's the one who called the police and came over to do a welfare check. And my client, as I stated in my motion, he complied with the police officer's request. He brought the child out. The police officer noted there was no problems with the child. The child did go to see the mother, and then the mother would let him have the child back, even though there was an agreement that he would have the weekend and the overnight. And they had actually modified the existing parenting plan where he was starting to have more time with the child, including weekends. And
the father's side pushes for major custody changes, even suggesting drug testing and questioning the mother's lifestyle, attempting to shift the court's perception of fitness. Financial willingness to pay for testing is highlighted to strengthen credibility. This segment shows how custody battles often expand beyond parenting into personal conduct scrutiny, with both sides trying to legally undermine the other's stability as a parent.
Then when he said, I want my child back, the police officer said, do you have a court order which gives you overnights? And he said, no, I do not. So he said, I don't have any authority. This is a civil matter. Bring this matter to court. So that's where we are now. Then from and after December 20th, he's had no contact whatsoever. Ms. Martin has said over and over again that she is the sole parent in this matter, that what she says goes. I have attached several exhibits, many exhibits in which she states that same thing, and saying she doesn't care what he says, she makes the determination. My client said that he has worked hard to have a relationship with his child, that his parents are here and they have a relationship with the child. And to be cut off from this child for 77 days now has been extraordinarily difficult. I don't want to go through point by point my motion because the court has already read it, or point by point with regard to my exhibits. But I would point out that one of the things we stated in our motion is that Ms. Martin has a habit of smoking marijuana consistently. In my exhibit 8, she talks about her purchase of marijuana when she has a text message with my client. We certainly ask that she be required to submit to a hair follicle drug test today at our cost. Let us know where it would be done in El Dorado, and I, with our firm credit card, will pay the cost if the court wants my client to submit to hair.
The father's lawyer proposes a dramatic change, seeking primary residential custody or at least structured shared parenting. He argues cooperation is impossible under current conditions and pushes for regular scheduled visitation for the mother instead. The court begins to see a clear strategy. One side wants full control, the other wants guaranteed access, but neither side fully trusts the other anymore.
Follicle drug test, he will do the same thing at his cost. We've asked for some pretty serious changes in the custody arrangement. We've asked that he be designated as the primary residential custodian, and we think that's appropriate under the circumstances. I point out in my motion the fact that she has violated virtually everything in the temporary parenting order about how you parent a child together. And then under the statute 233203, I point out 7 or 8 issues where it certainly favors my client. The rest are neutral or not applicable. He wants to be involved in his child's life. I put first, we want him to be the primary residential custodian and giving her regular parenting time. The second thing is, although it'd be difficult under the circumstances, he would work his best to do a shared residential custody arrangement, but that implies that both parties are able to work together. We think that she has not been willing to work with him. And with that in mind, that would, I think, support more him having primary residential custody and her having a regular parenting schedule, which we have proposed to be every Wednesday from after work till 7:30 or 8, and then on the weekends that she have every other Friday from 5 or 6 until Sunday at 5 or 6, and follow that.
The judge questions the mother about overnight visits, but she firmly rejects them, saying the child becomes distressed and overly attached. However, the court challenges this by pointing out that denying contact for over 70 days may itself be contributing to the child's anxiety. This moment highlights the core conflict: emotional concern versus legal responsibility to maintain consistent parental bonding.
The holiday schedule that was in place in the original parenting plan, we think is a strong basis, Your Honor, for the court to honor our request at this time, and that's what we're asking. And at the very minimum, that the court would order a regular parenting schedule, which is our our exhibit. It's our exhibit 4.
Which is alternative mom primary. Is that the one you're referring to?
Well, the last one is, and it's just because we want regular parenting time that she would be primary, although we don't think she deserves it, but anything to get him started to have meaningful contact with his child. And that's the last gasp that we'd have, but we do think that we've justified a reason for changing custody in our motion and arguments today.
All right. Ms. Martin, I'm sure you're familiar with the proposed permanent parenting plan, alternative mom primary. And what's wrong with that plan?
Me being alternative or me being primary?
You being primary, but it sets forth, I think, a rather structured and actually a fairly common parenting time schedule for the father. Are you just saying that he shouldn't have the child overnights ever?
Not until she's old enough, like a little bit older. She screams and cries even when he comes to pick her up just for a few hours.
The father's lawyer describes a stable home with a partner and separate bedroom for the child, portraying a structured environment. The mother's side is challenged with claims of overcrowding and co-sleeping arrangements. Both sides dispute the child's emotional response to visits, with each claiming the child behaves differently depending on the household. The court now weighs environment stability against emotional attachment claims.
She doesn't want to unlatch from me.
Okay.
I feel like she's not comfortable enough to stay overnight. She's been with me for 3.
Of course, keeping the child from the father for over 70 days, doesn't that help contribute to some of that?
Um,
Deprivation of the relationship between father and child, you don't think that has a negative effect on the child's willingness to go see her dad?
no, because before I was allowing him to have a lot more than even what we had scheduled. I was allowing them to have a lot of time and she was still doing it.
Okay, now I'm going to go back to Mr. Blanchard for a moment. Mr. Blanchard, tell me about your client's household. What environment does this child go into when she goes to visit her dad?
Okay, my client has a significant other, a fiance who's a very good person. She's about to have their child together. There's a 2-bedroom house. The child of the parties has her own bedroom. The new baby will be in a bassinet in their room for a period of time. In her living arrangement, as I put out in my motion, she has 6 people living in the house, and the child sleeps in the room with her and sleeps in a bed with her. We would also dispute her allegation.
The court directly questions whether the father can handle extended parenting time with a toddler. He responds confidently, describing routines, meals, sleep schedules, and educational activities. The judge also probes claims of adjustment issues, showing skepticism and trying to separate emotional claims from actual parenting performance. This section highlights how courts assess practical caregiving ability, not just arguments.
That the child screams and doesn't want to go with the father. That's not my client's experience, nor is it the experience of the grandparents who are here or his significant other who is also here. And if we went to an evidentiary hearing, all these people would testify as to a good relationship with the child when he's allowed to have contact with the child.
All right. Thank you for that additional information, Mr. Blanchard. What is apparent to the court is that the parents aren't working well together to share parenting time and parenting rights involving this child. The court generally is fairly protective of newborns, small infants. The court is always trying to be cognizant of who's qualified to really raise children of that age. But this child's toddler age. She's 3. And I'm sure she's a handful at times, as 3-year-olds are. Mr. Matlock, are you really in a position to handle as much parenting time that's on your schedule, which is a full weekend at a time and every Wednesday night?
Yes, we've actually done it for longer. It's usually a Wednesday and a Friday every week, and then we get some weekends. Whenever we have her, we have no problem with her. She's well behaved. We get her in bed at a reasonable time, 9 or 9:30, and she's up the next morning at 7 or 8. We have breakfast, lunch, and dinner. Kendall's got educational games on her phone that help her with her speech and pronunciation that she actually really liked. We have no problem with her keeping her entertained and eating healthy meals.
The father denies serious behavioral problems, saying initial adjustment issues faded quickly and the child sleeps normally in his care. The judge continues pressing both sides about credibility, especially regarding the child's emotional reactions. This moment shows how contested custody cases often rely heavily on subjective interpretations of a child's behavior, with both parents firmly believing their version is correct.
And just keeping
All
her.
right, Mr. Matlock, what about this claim that the child has real adjustment problems for several hours after going from the mother's home to yours?
In the beginning, yeah, it was a bit of a struggle to get her used to sleeping over at my house, but by the third night that we had her, not third night in a row, but just third night in general, she was having no problem going to sleep. She doesn't have any problems going to sleep. I could tell her to go to bed and she'd fall asleep right there. We do. I'll read her a couple of books that we have. She likes to read Dr. Seuss, Green Eggs and Ham, and we got a couple of Bluey books that she likes me to read to her. After that, she's out cold the whole night. No problem.
Okay. I expect straight answers on this, Mr. Matlock. Are you currently on probation for any offense?
No,
Do you have any criminal cases pending?
I do not.
Ms. Martin, I'll ask you the same questions. Are you currently on probation for any offense?
No,
Do you have any criminal cases pending?
no, Your Honor.
Okay. Again, it's apparent to the court that the court is going to need to set up a structured parenting plan for these parties to follow. And I'll warn both parties that if the court makes this order for specific times, I will expect both of you to.
The judge announces a temporary but structured parenting plan, emphasizing consistency and enforcement. A strict schedule is introduced, alternating weekends and midweek visits. The court clearly warns both parents that flexibility is expected but not guaranteed, signaling that future disputes will not override the official order. This is the moment where verbal conflict turns into enforceable legal structure.
Follow it to the letter. If you can't agree on variations, which is a shame, and I think that's tragic, because special circumstances will come up from time to time. But I would really hope that you two can learn to work together to be a little bit more flexible. But the court, I think at this point, needs to set a rigid schedule. At least at this point, the court will implement the proposed permanent parenting plan, though I'll call it a temporary parenting plan. Alternative mom primary, which was filed in the case. I don't see an exhibit number on it as far as the court file is concerned, but it's the proposal which calls for the father to have parenting time every other weekend, from Friday at 6 p.m. to Sunday at 6 p.m., every Wednesday from 5 o'clock p.m. to 7:30 p.m., and any other time that the parties mutually agree upon in writing, which I don't have any real optimism is going to happen until you two develop some sort of cooperation and rapport with one another. But I do want to set forth that every other weekend and every Wednesday night schedule. I think this child needs to get reacclimated to the father and the father's home. And I find it tragic that there's been a long deprivation.
Emphasizes that neither parent has superior rights and urges them to reduce communication conflict. The father is advised to use the mother as a parenting resource when needed, despite their differences. The judge also highlights extended family support as a stabilizing factor and stresses active involvement from both sides. This segment focuses on rebuilding co-parenting structure despite ongoing mistrust.